Hello, everyone, and I'd like to thank everyone who is joining us today for this Axis Masterclass, where I will be taking a deep dive in respect of the use of trusts and foundations in the context of estate planning. I just wanted to start this masterclass by providing you with some introduction and background on the topic that we're going to be discussing about this afternoon. First of all, let's try to get a better understanding of the concept of estate planning. What is estate planning? Well, estate planning is really the arrangement of a person's estate. And by a person's estate, we mean a person's belongings, whether that could be cash, shares, property, chattels, everything that belongs to a person and has got some economic interest. And when we talk about estate planning, we are really talking of the arrangement of that estate during the person's lifetime to determine what should happen to that estate after his or her demise. The ideal estate plan is, to me, one which focuses on what I call the 3 Ps. The first P stands for protection. The second P stands for preservation. And the third P stands for passing over. And during the course of the presentation, we will expand on these 3 Ps a lot more. And you will get to understand what I mean by each term. But I think it suffices to say at this stage that very often clients focus on creating wealth, but very often overlook the steps that are required to deal with the 3 Ps, i.e. to protect, to preserve, and to arrange how this wealth is going to be passed over once they are no longer with us. And hence the famous proverb that you probably would have come across before: the wealth of a family never lasts for more than 3 generations. What does that mean? I've been saying that in a lot of my previous presentations, and those of you who have attended previous presentations would probably know it by heart, but for those who haven't, the first generation generally is a generation that works extremely hard to create wealth. So there's a lot of sweat, a lot of effort involved. And very often this would be the generation that would be really spendthrift. They would not really spend a lot, because they understand the effort that is required in creating the wealth in the first place. The second generation reaps the benefits. They've been born within, with as they say, a golden spoon. So they have a very comfortable lifestyle, and so they reap the benefits. But by the time you get to the third generation doesn't really see the value of hard work, because they are terribly disconnected with the first generation, be it culturally or, there is so much gap between the first and the third, and therefore they squander the wealth. And therefore, by the time you get to the third generation, if you haven't really planned accordingly, the reality is that the wealth may well have been dissipated. There are also other reasons why wealth may dissipate during the course of time, and this includes, for example, death taxes. Some jurisdictions would have death taxes, so that when you pass, then there is a tax, inheritance tax, that is levied on your assets. And sometimes the extent of the tax is so high that the heirs would be forced upon to sell whatever they are inheriting just in order to pay the tax. Inflation, of course, bad investment decisions, and then, of course, the natural dilution of assets as they are shared amongst generation of heirs, right? It's like a pyramid. As You go down the pyramid, you have more and more and more and more people. And so when you divide the estate amongst so many people, there is a natural dilution process. Now, it's important perhaps for me to state at the outset, contrary to the popular belief, that estate planning is not only for the rich. It concerns everyone who has belongings and who may want to ensure that these belongings are adequately protected, preserved, and passed over. So please do not think that estate planning is only for the rich or the super rich. It is for all of us. So if you want to create an estate plan, and a lot of you who are joining us today are practitioners, and you are looking at advising your clients, what are the tools that are at your disposal in order to create a good estate plan? Well, I suppose that the most used tool for estate planning, albeit in the civil law world, including Mauritius, is the will. It is also probably the tool that, I mean, you don't need to be a lawyer or an expert in estate planning to know what a will is. It is a legal document that spells out one's wishes regarding the distribution of assets after their death. And a lot of people would create wills before they die. In Mauritius, you would do that in front of a notary, but certain countries allow you to create wills without any particular formalities. However, the will only deals with one of my 3 Ps. Remember, we talked about the 3 P, protection, preservation, and passing over. The will only deals with the 3rd P, which is the passing over, but does not really deal adequately with the protection and preservation side, as we will see in a moment. Now, if you know what a will is, you will know that a will takes effect upon death. And once a person dies, if a person has made a will, then the will dictate what happens to the person's estate immediately after his demise. And it will generally lead to an immediate and direct transfer of assets to whoever are named as heirs of the person who's made the will after his death. So say, for example, you have a client who's made a will and who has provided that in the event of his death, he would like his estate to be equally divided between his spouse and his children. As soon as he dies, the assets will be divided and will immediately be transferred to the heirs, right? So as you can see, whilst this deals with the matter of disposal of the estate, i.e. the passing over, it does not really deal with the other piece, namely the protection and the preservation. Let me give you an example. If you have a client who has a business and he provides in his will that once he dies, his heirs are going to become the owners of the business in equal shares, the will does nothing to ensure that the business will not be fragmented post-demise. And there are many examples of that you probably have come across in your own family. So in Mauritius, there are a few examples that are of public domain. When the patriarch dies, if they have a business, the siblings don't get along, and what happens is the business is then fragmented. You have also a lot of other international examples. The most famous that I can think of is the case of the Ambani brothers in India, who, as you know, inherited a very successful business that was set up by their father called the Reliance Group. And when the father passed away, the 2 brothers could not get along. They tried to get along, but they didn't. And then Reliance Group was split, and one brother took a part of Reliance and the other took the other parts of Reliance. So as you can see, the will does not really ensure that certain parts of the estate are protected and preserved, right? The other problem that I see with a will is that it is immutable or fixed in time and cannot be changed once it has come into effect. As I mentioned before, the will comes into effect when the person dies. Until that point, the will can be changed. But once the person dies, you cannot change whatever is in the will because it takes effect upon death and the property is transferred in accordance with the provisions of the will. What happens if there is a change in circumstances after the testator's death? No change can be made to the will to preserve and protect the estate. An example is if you have a heir that eventually becomes bankrupt. Well, if you have disposed of your assets by way of a will, assets will become the ownership of the heir and will therefore be available to his creditors in bankruptcy. So the will does nothing to protect or to preserve those assets. And there are many other examples as to the fact that the will does not really protect or preserve because it takes effect upon death. This is why when we look at the common law world, for example, we tend to see that the trust tends to be the preferred estate planning tool as opposed to a will. And we will see in the later parts of this presentation why that is so. But you already get the impression that it must be different to the will, which, as I mentioned, takes effect upon death and cannot be changed. Similarly, foundations, which are a relatively newcomer, are being increasingly considered by practitioners in the civil law world in the context of estate planning. Again, because it has a number of benefits over the will. So let's take a bit of a deeper dive into trust and foundations, just to understand what they are, and that will then enable us to move on to why are they better than wills. And please, I would ask those who are already very familiar with these concepts to forgive me, but for those of you maybe who haven't really worked with either products before, I'll just give very broadly some background to each of these products. Let us begin with a trust. What is a trust? Well, to keep it very simple, a trust is a device in which rights, either personal or proprietary, are held by one person for the benefit of the other. That's what a trust is. A lot of people think a trust is a very complex product, but it's not, right? It's actually very simple. The person who creates the trust is called the settlor. The person holding the rights is called the trustee. And the person for whom those rights are held are called the beneficiaries. So as you can see, a trust is simply the interposition of a third party between the donor of a right and the recipient of that right. It's as if you have just put someone in the middle of the transaction. Instead of giving the asset directly to the recipient, you are putting a third party in between. And later on, we'll see why that becomes very interesting in the context of estate planning. Now, for a trust to work, it is fundamental that this third party who is coming in between the donor and the recipient has certain duties. And those duties are essentially that if the trustee misbehaves, then they will have committed what is called a breach of trust for which they will be liable, right? And the control of the trustee may, under the terms of the trust, be subject to a number of other duties, fiduciary duties, personal powers, etc. And you also sometimes have a fourth party that comes into the trust who is called a protector. We'll come to the issue of a protector later on. Some trusts may also have another party, which is called an enforcer. That would only be the case of purpose trusts. And the duty of the enforcer is to enforce the trust, as these trusts will not have beneficiaries, but this is not really the subject of our discussion today. So we'll park this question of purpose trusts and enforcers for the time being. And maybe we might have a masterclass one day on purpose trust where we can come back to that. But perhaps just in a nutshell, again, just to understand what a trust is, it is simply the interposition of a third party between a donor and an intended recipient. And that party is called a trustee. And that party will have a lot of powers, but also a lot of duties. So that's what a trust is. And here you have a diagram that really enables you to understand that easier. So you have a settlor who creates the trust. So he's the donor. You have the beneficiary who is the intended recipient, and you've got the trustee in the middle. What is a foundation? A foundation is very similar to a trust in terms of its purpose, but it is also very different to a trust in the sense that a foundation, excuse me, is a legal entity. As you would have seen in the previous slide, a trust is not a legal entity. It is just a relationship. You're putting someone in the middle, and that person, you are basically trusting that person to hold your property and manage it for the benefit of a beneficiary. It's not a legal entity. But when it comes to a foundation is very much like a company in the sense that it is incorporated by a relevant authority. In Mauritius is the Registrar of Companies. But otherwise, apart from the fact that it is incorporated, it functions very much like a trust, because you will also have someone who will create it, like the settlor of a trust. Here it's called the founder of the foundation. The founder will be very much like the settlor, because the founder is the donor of property. And you will also have beneficiaries, right? And the beneficiaries are the intended recipient. So in that sense, it's similar to a trust, but it's different to a trust because it is a legal entity. The other difference between a foundation and a trust is in respect of their governance. The trust is governed, managed by a trustee. A foundation, because it's a legal entity, has a board, which is very much like a board of directors, and which is called a council, right? But council members are also going to be subject to duties, right? A bit like trustees, because again, they are looking after property that doesn't belong to them. So they will have duties and they will have powers. So you can see already that trusts and foundations are quite similar, but not exactly the same, because one is incorporated whilst the other is not incorporated. Again, a diagram just to illustrate the parties to the foundation. So you have the foundation in the middle, which is an entity. Remember when we had the diagram for the trust, we did not have that middle balloon. And then you have the council, which effectively manages the foundation. You have the founder on the left, and you have the beneficiaries on the right. So again, you can see the addition of a third party between donor and intended recipient. Both of them serve effectively the same purpose. So what are the attractions of the trust and the foundation in the context of estate planning, right? Well, I think, as I mentioned before, what makes a will not really attractive is the fact that it doesn't address the first two P's, protection and preservation. What makes foundations and trusts attractive as compared to a will is that it is not immutable or fixed in time, unlike a will. A foundation or a trust takes effect at the time of its creation, but the assets do not pass to the heirs directly. You would have seen that already, because the assets are vested into a trustee in the case of a trust, or into the foundation in the case of a foundation. So they don't pass to the heirs directly. And that is very interesting. Why is it interesting? It is because of the first two P's. Because if it does not pass to the heirs directly, then you are achieving the protection side of the assets. Why? Because the assets do not belong to the heirs, and if they do not belong to the heirs, therefore they cannot be affected if something happens to the heir, to the beneficiary. We took the example of bankruptcy at the beginning. If you have a foundation or a trust whereby the intended recipient is only a member of the class of beneficiaries, and that beneficiary has got discretionary interest, and we'll come to the meaning of discretionary interest in a moment, then the assets will be protected even if the beneficiary becomes bankrupt. So you would have ensured that they are protected. The second reason is flexibility. I mentioned it before. Once you do a will, you can change it until you die. After that, you can't change it anymore. Within a trust and a foundation, you can provide for a lot of flexibility in what should happen to the assets after you have died, right? So you can bring a lot of flexibility in the trust instrument. For example, you could even provide that in certain cases, a beneficiary's interest will be forfeited or terminated, right? So if your beneficiary is misbehaving, you might include certain provisions in your trust instrument or in your foundation charter to provide that a beneficiary's interest is liable to be reduced, terminated, suspended, which you can't do with a will. They can also provide for the enjoyment of rights to be split on a plane of time, unlike a will. Remember, a will is fixed. Once you die, the assets get transferred. In the case of a trust or a foundation, you could provide, for example, that, well, your children will not get anything until they are of age, i.e. They have 18 years or 21 if you want. You can provide, for example, that as far as possible, beneficiaries will only get income, they won't get capital. So you wouldn't pay capital out of the trust or out of the foundation. You could provide, for example, that capital should only be allowed in certain very specific circumstances. For example, if someone is sick or if someone is in big trouble, then you will be able to pay out of capital. So there is a lot of flexibility that you can build into your trust or into your foundation so that you can provide for the enjoyment of the estate to be split on a plane of time. Unlike a will, you can provide that beneficiaries will only get a capital distribution, you know, when they get married or when they have children. So there is a lot of flexibility. And as I said before, unlike a will, you can make the rights of the intended donees to be subject to termination, to diminution, or suspension in given circumstances. This is not possible with a will. Last but not least, you can also, and this is very much a trend now, that you also want to include some philanthropic objectives within your estate plan. And both trusts and foundations lend themselves very well to philanthropic objectives. And again, when it comes to philanthropy, this is also where flexibility is very important. So the attraction of a trust or a foundation is that you don't even need to determine which charity will get a benefit, but you can basically give that discretion to the trustees or to council, you would provide them with a framework and you would tell them, look, this is what, the types of charitable objectives that I like. I leave it to you to determine which charitable body best meets with these objectives. You wouldn't be able to do that with a will. With a will, you would have to notify, you would have to determine, designate the charitable bodies that you want to benefit. So you've seen, therefore, the attractions of trusts and foundation from a generic perspective. And these attractions are only possible because of that interposition of a trust or a foundation between the person making the gift and the person to whom you intend to benefit, right? And remember, I said at the beginning that trusts and foundations, estate plan is not only for people who are very rich. You would want to interpose a third party between the donor and the intended donor. Let me give you an example. If, for example, you have a child who is sick, right, and who is incapable of managing their estate, a trust or a foundation would be the appropriate method by which you would put your estate into either a trust or a foundation, and you would then have a third party, trustee or the foundation council, that would be empowered to manage that estate for and on behalf and for the benefit of the sick child, right? Or you might want to look after, people who are old, right? You probably, the client has got no children. They want to look after, an old uncle, parents, etc. So the use of a trust or a foundation could also be because the intended donors may be incapable of managing rights because of age, because of illness, or otherwise. Remember the first P, protection. Properly structured, a trust or a foundation will effectively allow you to ring fence your assets, right? Ring fencing means that these assets are no longer considered to be part of your estate or the estate of the beneficiaries. They don't have a vested right in the assets. And therefore, if neither you nor them have a vested right, then these assets no longer form part of yours or their estate, right? And therefore, they will be protected against claims. There could be different type of claims. There could be claims by creditors because you are probably an entrepreneur. You're taking a lot of risks. And therefore, the foundation or the trust will make sure that if ever something should happen to you as an entrepreneur and you become, say, bankrupt, then the assets that you've put into your structure are not available to be seized by creditors. Spouses as well, in the case of a divorce, we see a lot of clients would set up trusts so that in the case of a divorce, they can also ensure that the assets are protected. Obviously, these need to be done in line with the requirements of the law, and the law provides for situations where the assets will be protected from a claim by creditors in particular. So obviously, whenever you're structuring a trust or a foundation, you'd have to look at the legal provisions, especially in respect of a bankruptcy. Last but not least, both the Trust Act and the Foundations Act contain a number of firewall provisions. These are provisions which are aimed at preventing a trust from being attacked, either on the basis of succession rights, marriage, divorce, insolvency. So again, this is to ensure that you are protecting the asset, which is one of my 3 Ps. And obviously, if you're protecting the assets, it also means that you are preserving them, which is my 2nd P. So moving on, I just talk about the asset protection features. I'm not going to go into too much of detail, but it suffices to say that both in the Trust Act and in the Foundations Act, you have a number of sections to protect the asset under a trust or in a foundation. So I'm just going to read the sections. This PowerPoint will be available to you after the masterclass, and you can go through them at your own pace. 3 sections to protect transfers of property to a trust: Section 7, subsection 6, Section 8, subsection 3, and Section 8, subsection 4. And these are measures to protect that, to make sure that when someone transfers property to the trust, that transfer cannot be declared void or invalid. So therefore, you are making sure that the transfer of property is not void or invalid, because that's one of the ways in which a trust can be attacked, right? By saying, well, actually, we're not attacking the trust directly, but what we are saying that the transfer to it was void or invalid. So we have measures to prevent that from happening. We have similar sections in the Foundations Act, Section 4, subsection 2, and Section 4, subsection 3, in respect, again, of protecting transfers of property. And then we have additional provisions in the Trust Act that prevent the trust from being attacked, right? So Section 11 in particular of the Trust Act contains a number of provisions aimed at preventing a non-resident trust from being attacked on the basis of succession, marriage, divorce, and insolvency. Important to note that there is a big difference between resident and non-resident trusts in terms of these firewall provisions. So if you are advising a client, make sure that you understand the scope of these anti-attack provisions, because a lot of them do not apply to resident trusts, but only to non-resident trusts. Right? Creation, I'm just going to speak extremely briefly about creation of trust and foundations. It suffices to say that a trust can be created very easily and speedily because it does not necessitate any formal requirements other than an instrument in writing. There are no registration requirements. Okay. Whereas when it comes to a foundation, there's a formal process which involves the incorporation with the registrar of incorporation. That's all I want to say on setting up. I don't think there's anything else to say about setting up. As I told you, it's probably easier to set up trust because it can be done very speedily, because you don't need to rely on a third party for it to be established. But when it comes to a foundation, you do. But then again, it only takes a few days for a foundation to be incorporated. The governance side, as I mentioned before, a trust is managed by the trustee. The trustee is the legal owner of the trust property, and he holds it for the benefit of the beneficiaries or for the fulfillment of a purpose, but we're not going to go into purpose today. Important to note that you can have up to 4 trustees for a Mauritian trust, and there must be at all times 1 qualified trustee. And a qualified trustee is defined as a management company or any other person resident in Mauritius as may be authorized by the FSC to provide trusteeship services. And interesting to note that some clients want to have their own trustee company, which is not an MC, and the law allows that. It's called a private trust company. So, for example, if a client tells you, well, yes, I want to create a trust, but I don't want you to be my trustee. You can tell the client, fair enough, it's not a problem. We can create a private trust company for you, which will act as the trustee of the trust. Okay. Under the Act, it's also possible for the act of trusteeship to be split into two trustees, namely a custodian trustee and a managing trustee. Trustees have extensive powers to manage the trust, which are similar to the powers of the beneficial owner, and trustees can obviously consult, delegate, be remunerated, appropriate, accumulate, advance, appoint property, revoke and vary the trust, invest trust funds. So powers of trustees are quite extensive, but as I mentioned, these powers are subject to very scrupulous duties. Another interesting aspect of both a trust and a foundation is that the settlor or the founder can give the trustees or the council a letter of wishes, right? The letter of wishes is not generally a legally binding document. So technically trustees or council members may depart from it, but it is very useful in providing guidelines to trustees and to council members as to the wishes of the founder or of the settlor. Because very often, you know, a professional trustee or a professional council member may not know the settlor that much to know what are his wishes. So a letter of wishes is very useful because it is a means by which you get to know about your settlor's wishes. A settlor can be a trustee, right? But not the sole trustee. A settlor can also reserve certain powers to himself, but I don't like reserve powers because it is a bit risky, because sometimes if the reserve powers are too extensive, the trust can be regarded as a sham. I mentioned that before, protector. You can also decide that you want to have a bit of control on the way in which the trustees exercise their powers. So you as a client may say, well, I don't want to just put all my trust in the trustee. I want someone else who can act as a check and balance. So that's a protector. A protector can be given certain powers to consent to certain types of transactions. And it's, again, very flexible. You decide what are the powers that you want to give to the protector. And I also mentioned that clients who want to have their own private trust company may also do that under the legal framework in Mauritius. Liability, just very quickly, because we're not going to go into that much of detail. It suffices to say that trustees are personally liable, right? So if they neglect their duties, if they do something which is not authorized or which is not excused by the terms of the trust or by law, they will have committed a breach of trust for which they will be personally liable. And I like to say that personal liability simply means you have to put your hand in your pocket and reimburse the trust for any loss that has been caused by your act or by your neglect. You can exclude some liability, not all of it. There is what is called the irreducible core of duties that you can't exclude, but otherwise you can exclude liability for quite a number of things. A foundation is managed by a board. I told you about it earlier on. It's called a council. It's very similar to a board of directors of a company. It can comprise of natural persons and body corporates. It must have at least one member who must be ordinary resident in Mauritius. But as compared to a trust, there is no requirement for a licensed council member. So it can be anyone so long as that person is resident in Mauritius. But for a foundation, you need to have a licensed secretary. And again, the licensed secretary is either an MC or someone who is authorized by the FSC. Similar to trustees, council can appoint officers. The powers that they have are very wide. There is a possibility of having a protector also, as is the case for the trust. And it's also possible to have a letter of wishes for the foundation. So again, you see the similarities between the two. So the council must conduct the affairs of the foundation in accordance with its charter and articles and the act. It is responsible to supervise the management and conduct of a foundation. They must act honestly, in good faith. and exercise the care and that a reasonably prudent person would exercise in comparable circumstances. So similar to trustees, but not to the extent of personal liability. I think that's where the major difference is between a trustee and a council member. A council member is not going to be personally liable for loss caused to the foundation unless they have been fraudulent or grossly negligent. So here, liability-wise, council members are better off because they are treated more like directors and not as trustees. So when you're choosing the type of the product, right, from a liability point of view, foundation seems to be more interesting for the service provider. But trusts probably are more interesting for the client because they have the benefit of personal liability. Beneficiaries, well, very quickly, beneficiaries can be natural persons or body corporates, right? They must be identifiable or ascertainable. The interest of a beneficiary under a trust is considered to be movable property. Also under foundations, they can be transmissible, they can be sold, pledged, charged, transferred, or otherwise dealt with, provided that the beneficiary has a vested interest in the trust or the foundation. The trust instrument, but also the charter can provide for beneficiaries to be added, removed, subject to an obligation as a condition precedent, terminated, restricted, alienated. So both of them are quite similar in the way that beneficiaries are treated for both a trust and a foundation. I have already covered that. And the last part before I open for question is how are foundations and trusts taxed? Well, this is where there has been a major change in the law this year. It used to be the case that tax law distinguished a resident trust or foundation from a non-resident trust or foundation on the basis of the residence of the settlor and beneficiaries. So a trust or a foundation of which the settlor or the founder and beneficiaries were non-resident of Mauritius during the fiscal year could deposit a declaration of non-residence with the Mauritius revenue authorities. And such a trust or foundation would then have been considered not to be resident in Mauritius for fiscal purposes and would not have been subject to taxation. Following the enactment of the Finance Act of this year, the availability of the declaration of non-residence for trusts and foundations have been repealed. Grandfathering provisions, however, exist up to the income year ending 31st of December 2024, which allow trusts or foundations set up before 30th of June 2021 to continue to benefit from the previous system. The new test for determining whether a trust or foundation is resident for tax purposes in Mauritius is now central management and control, as is the case for companies. And the MRA has recently published a statement of practice to clarify what would constitute central management and control for a trust and a foundation. I think, to cut a long story short, so long as your settlor and the majority of your beneficiaries are non-resident in Mauritius, the trust or the foundation would not be considered to be centrally managed and controlled in Mauritius. And therefore, the end effect is that a trust or a foundation of which the settlor, founder, and the majority of beneficiaries are non-resident of Mauritius will continue not to be subject to taxation in Mauritius unless they are deriving taxable income from Mauritius. So it's pretty much the status quo for offshore trust and foundations. I think my concluding remarks is that do not overlook the attraction and benefits that could be derived from the use of a trust or foundation in the context of estate planning. If you would like to have more information, please do not hesitate to contact us. As you know, Axis Fiduciary is one of the leading management companies in Mauritius, with a presence not only here, but also in the Seychelles, in South Africa, and in Kenya. And we have a growing private client practice, and we already help a lot of clients who have used our services and our expertise to establish their private client structures. We are also one of the employer partner of STEP. For those of you who do not know STEP, STEP is a Society of Trust and Estate Practitioners. It is really the organization that regroups people like me who do a lot of estate planning work. And it is also a great organization. If you want to know more about STEP and how do you become a member of STEP, please also let us know, and we will be very pleased to advise you. So on that note, I'd like to thank you very much.